in cabin planning or lake property planning. It doesn't have to necessarily be lake property that someone owns. It can be hunting land. There's a lot of different types of family properties that pass through the generations that people would like to keep going in the family and give the next generation the right tools to deal with owning it, paying for expenses, all of those sorts of things that people are going to need to continue to do. Whether you have experience with this because you've owned this property in your past, it's been passed down to you maybe, or because you bought it yourself and you would like to pass it down. There's a lot of things that if you're not already doing these things, you're going to want to at least look into setting up the right structure for ownership. So welcome everybody. I'm attorney Justin Randall here with Hooper Law Office. Our topic today, again, is kind of up north cottage, hunting land, lake property, that kind of planning for that. This was explained to me. I'm not originally from Wisconsin, so this was sort of explained to me in a way that I thought was unique and kind of funny, and its own sort of quirk of kind of Wisconsin in some ways. Is what is up north, and it depends so much on either where you're from, where up north actually is in relation to you, but also sometimes it's not so much that it's actually even north. It can be that it is just wherever you have this property. So it could be west of you, it could be south of you, it could be east. So it's up north is just really everybody's up north is different, right? It's not the same for everyone else. It's relative to where you have your family cottage property or hunting land. But everybody has, or a lot of people in Wisconsin have their sort of up north property. And up north is sort of near and dear to their heart, and they have a lot of family memories there. So a lot of times people would like to pass this property on, especially if there's actual interest in the next generation of owning these properties. And maybe the property has already been passed down through the generations to you. Maybe you're the second generation or the third generation. And there's things that even if it's been working pretty well so far and there hasn't been a lot of issues, there may be things that you want to tweak about like ownership structure or agreements of how to price a buyout if somebody wants to be wants to sell their interest, and what the best ways to structure all of those sort of potential points of conflict and how to get around that even being an issue. So just before I go too in depth in that, a reminder, if you're participating via Zoom, if you're on the Zoom call today, you can actually ask questions in the Q&A function. I'll see those pop up. So please feel free to, if anything, any sort of questions related to this topic comes up or sort of semi-related to this topic comes up, please feel free to put that in the Q&A function and I'll be able to answer it live here. And if there's ever anything that you don't want to ask on the Q&A function, it is anonymous. Nobody, will see it other than me. But it is, you can always give us a call or give an email to learn more at hooperlawoffice.com, and one of us will be in touch with you. At the end of this webinar, if you signed up in advance, you will receive an evaluation form and also our handout of our tools for up north property planning, and sort of a grid of different tools you might use in that planning. That will be sent to you after this webinar. And the evaluation form also has a place where you can mark that you would like us to reach out to you to set up time to do an initial consultation if anything we talk about today is something you want to plan around. And those initial consultations are complimentary. We usually schedule them for about 2 hours. So it doesn't cost you anything to come in and talk to us about some, cabin planning concerns or general estate planning concerns that you might have. So kind of getting started, I've talked a little bit about what, up north actually means to a lot of people. And it's really, up north is not the direction north, it's where do you own your property, and it's different for everybody. And your up north might be hunting land. It might be family cabins that you have, or a cottage on a lake, right? Which I did not know until recently. There is apparently a difference between a cabin and a cottage, but that was interesting, I thought. But generally, this type of ownership structure, especially if you're, or this type of property, if you're trying to pass it down to the next generation, you want to set that generation up for success when they're owning it. And what a lot of people do, and unfortunately doesn't provide that structure, is they just sort of pass it down through their estate plan, equally to their kids, or, split amongst a number of kids, or maybe they gift it over during their lifetime and just transfer the deed, but they just own it as individuals. And this can create a lot of problems. It's not so much that the transfer itself always creates issues, although there can be issues with that, which I'll touch on. But it's also somebody just owning property outright doesn't provide them with the dispute resolution tools they might need, or what happens if somebody doesn't pay their share of expenses, or how do you fairly price a buyout if somebody doesn't want to own it, and how does that work, right? Is there usage restrictions in terms of calendaring, and you get it for this week and I get it for the next week if there's ever any concern about that. But owning it just by an outright owner as an individual or a group of individuals does not provide you outright with those sort of tools. And a lot of times what that can create is conflict. If there aren't any sort of disputes, or if there are disputes that come up and there aren't the tools to deal with those disputes, or rules that were agreed upon ahead of time, sometimes these properties that are meant to keep families together can actually end up driving a wedge between family members, because they get upset with the other, sibling or cousins, and all of those sorts of things. Another thing that a lot of people, unfortunately, can create issues, not necessarily on the first generation, but as the generations go down the line, it is they don't restrict possibly the number of owners on these properties, or who can be an owner. Does it have to be a descendant of yours? Does it have to be a direct lineal descendant, or can spouses, through marriage, can they be owners as well? Are you limiting the number of owners? So, maybe the generation you're passing things to, maybe you only have 2 kids, and that's not too many owners generally. That's pretty common, at least. But maybe the next generation, maybe each of them has 5 kids. So now you're splitting up into 10 different owners in the third generation. And does that then split up into a multitude of that at some point? There's a story, I can't remember exactly how many owners it is, but it was a lot. It was dozens who owned a lake property, and they literally had to have family meetings every year just to decide on how to pay for the property taxes, because there were so many different owners. And so these tools that end up, or the properties that were supposed to keep families together, they end up sometimes not being set up for success, because you're not giving anybody the tools to deal with it. You're not limiting ownership in a way that provides a reasonable amount of owners the ways to buy out the other owners if they want to, or decide on how to pay these expenses, or limit usage, or protect them from liabilities. So there are things you can do, and you will want to talk about doing with your family, especially if you own it with other siblings, of setting up to protect each other and yourselves. So, one of the big things, the issues that comes up is the taxes and expenses, right? If somebody just owns that property, in theory, or is an owner of the property, in theory, they should be paying their fair share of those expenses and property taxes, utility bills, things like that, based off of their percentage of ownership at least. So if you equally own it amongst 4 people, you should each be taking on your fair share. Now, you can obviously always agree independently to cover somebody's share if they're having a hard year, or whatever it might be. But if somebody just continuously is not paying their fair share, but they're an owner, what tools do you have to either take that person's ownership away, or what happens if they're not paying their fair share? So I did just get a question: what if one owner wants to build a pole building on the property? So if there's ever any sort of, it depends on your ownership structure, but if you guys just own it outright, if you own it as individuals, in theory, you have a certain right to build things on the property, as long as there's zoning, rules aren't being violated, or no other sort of, municipal laws are being violated by building something in a certain way. But if there's a dispute on maybe you don't want that building there for a number of reasons. It can be difficult because you have competing interests now. So ideally, you would have a structure set up to deal with those sort of disputes of what can be done, or if you have sort of like a committee amongst family members of, okay, this is the gatekeeper of who decides what can and can't be done. So in this case, it's others. There's not really a care of whether they build that pole building, but is it they just don't want to chip in the money for it. And in theory, the person who wants to build it, if there's no concern over the fact that they do build it, but the others don't want to chip in money, you can't force people to chip in money for something that they don't want to spend money on. Unless there is some sort of entity owning that property and you are all owners of that entity, and maybe that, so like a business entity, for example, may have rules associated with, okay, if we all agree to pay or to build this property, we all have to, chip in. Or if we don't chip in our fair share, what happens? But if this is just outright ownership, potentially, which a lot of times is the case, that person who wants to build that building cannot force other people to chip in, which is one potential concern if that person wants them to chip the other people to chip in for that building, but they can't force them to necessarily. And the other concern would be, though, is the person building it, if they're not having other people pay in for their share, does that create any sort of concerns with, does that person expect to be paid back for that in terms of if they sell it? Are they going to be upset if they're not compensated for it? So there's a lot of things that could create issues with if it's not addressed ahead of time. That would definitely be a good example, though, of, you and your siblings who own that property, or the other owners who own the property, coming in and talking to one of us would be a really good idea, so that you can really iron out those details and give yourselves and the next generation potentially the next sort of, or best sort of tools for success. So that's a good example, though, of some sort of expense coming up where maybe you're not, maybe not everyone wants to pay. So that can be another sort of thing that you want to iron out in a business entity owning a property, where you say, what kinds of expenses do we need to chip in on? Is it only the upkeep and expenses of things like property taxes and utility bills, or is it anything that we're building new property or new buildings or improvements on? And how are those improvements factored into, compensation for that person later? Do they have a right to receive the value back for the improvements they've made? Or is it just sort of, if you want to do it, you can do it, but you're not necessarily going to be compensated for it. You're just getting your ownership interest back. These are things you want to agree on, not because you're necessarily obligated to agree on these sorts of things, but the problem can be if you don't, and then somebody is upset about that disagreement later. These are the sorts of things that can just create conflict in families that you don't want to see, because these properties are meant to be things that bind people together, not drive wedges between them. So another kind of aspect of things that people don't really talk about is, well, how are decisions made? Are there decisions that require, majority approval? Do they require unanimous approval? How do you set these sorts of conversations up? What has to be done before somebody can do something, like in that example, building a building or an improvement on the property? Do you all have to agree on it, or is it just a majority? Or, how is that set up? And then one other thing that I've seen, not necessarily so much with like family properties owning it together, but with other real estate, somebody was on a property as like joint tenants. They were joint ownership, they were joint tenants with right of survivorship, many different ways to refer to this, but essentially how this functions when you're joint tenants on a deed. The moment one of those owners passes away, the ownership that they have does not go to their descendants necessarily. If that was the intent, it goes to the other owners. It just gets kind of redistributed out amongst the surviving owners. So you want to also make sure that your ownership is set up in a way that your ultimate estate planning goals are honored as well. You don't want to go into a joint ownership and think, oh, if I pass away, my share is going to my family. because it may not, unless your family is also joint owners with you, right? It may go just to the other owners, or in particular, if it's joint ownership that way. So if you do just own it as an individual, joint ownership is the one that can create the most conflict if you're not aware of what that sort of transition of ownership looks like. But even the alternative, tenants in common, where you each own all of your share and can do whatever you want with your share, even that's not overly ideal in the long run when you have multiple owners on a property, other than like husband and wife ownership, right? Because again, it does not provide you with the sort of entity structure to deal with disputes. Another sort of concern people tend to end up with, they don't necessarily think about in advance, just because it's not where their frame of mind is when they do these sorts of planning, or passing on these properties, is what happens if one of the owners has a liability that comes up, not necessarily tied to the property, but what about things like long-term care? If you need assisted living or skilled nursing assistance at any point care, you own that property, you each own your share. And for, under most circumstances, that's going to be a countable asset for someone's care, meaning they may have to have a lien attached to it or spend down through it. And how does that look like for the rest of you? Are you now suddenly obligated to pay off that lien if they can't? Are you, is that going to disrupt your ownership? Or are you going to have a forced sale that you didn't want to have? So these are the sorts of things you want to have dealt with. So what most people tend to do is they just kind of tend to pass on these properties, or they maybe even have a really well-crafted estate plan, but they don't have an entity structure set up for these properties. There's no ownership like through an LLC or through a business entity. It's just individuals that own it. And that can create a lot of problems because there's just no real way, other than through entity ownership and agreements that you've signed with each other, to set up that binding structure that, these are the rules that we've set up for our family, and these do have to be followed, or else here's the consequence. And the consequences can vary, right? It could be, well, does their ownership diminish over time if they're not paying their fair share of expenses? Does a debt against the business entity start to convert into ownership for the other owners? If you're not paying your fair share of the property taxes for 10 years, what happens to that owner? Do they just get to stay as an owner, or are they slowly sort of converted out of the business because they're just not participating? One other thing, and this is more of just one of those things that can be a real headache for people when they're not aware of it, is if you just own things as individuals, what happens if one person wants out? What if they don't want to be an owner anymore, but none of the other owners want to buy them, or maybe can buy them out? Try selling like a 1/5 ownership in a property with a family that somebody doesn't know to just some third party. That's going to be a really tough sell. It's not very marketable on the real estate market to do that, because if you think about it from your perspectives, you probably wouldn't want to just buy into some cabin with a family you don't know. So it can be really difficult if someone does want out, or has reasons they may not be able to be an owner of that property for their own financial reasons. If they can't get the other owners to buy them out, or they can't agree on a price, you kind of end up stuck. And then really one of the main solutions to that is a sort of a forced sale, like a judicial forced sale, where they say, all right, if nobody can agree, the only equitable remedy here is you all have to sell. And that might not be what you want either. That's a very extreme last resort, but it is something that can happen. So the better thing to do is, ideally before it even passes on to the next generation. So maybe you and your spouse own this property together, and you're thinking of passing it on to your 5 kids. Ideally, what you would do before you did that, before you even passed away, is set up some sort of entity amongst yourselves, and you get to decide those rules, right? If you want to make sure the family gets along, your kids in particular, you and your spouse, or you yourself, if you're the only, maybe you're the surviving spouse, you can set up these sorts of business entities to deal with these, and you can set the rules. And when it passes on to them, you're really passing on not just the ownership of that real estate, but also the ownership of that business entity. And as new owners of that entity, they may be bound by the terms of the entity that you're passing on. If they want to be owners of that entity, they have to sign on. Now they can always, there's always mechanisms for these to change their own rules, but you can set up, certain types of requirements of how those rules have to be changed. I sort of talked about, majorities or super majorities, or does it have to be unanimous? Those sorts of kind of bars that someone has to pass before rules can be changed. So one of the most common things we do, the entity-wise setup for these sorts of properties is an LLC. An LLC is a limited liability company. The idea behind that is what's in an LLC is sort of separated off from someone's personal assets, right? So that can protect your personal assets as an individual from the liabilities of that LLC. And the sort of common misconception people have is, oh, you put anything you want to protect in an LLC, whereas really it's more of that separating line that you're protecting yourself from the liabilities of the LLC. And this can be very important with like lake properties and cabin properties where people have multiple owners, and are they inviting their buddies onto the property, and maybe somebody gets hurt. You don't want to be liable for that personally, because it wasn't even your friends, maybe it was just somebody on the property. So that's where an LLC can really provide that liability protection for the rest of the owners from maybe something just going wrong. Maybe somebody wasn't even being irresponsible, but just something happened. Anybody can sue anybody for any reason. It doesn't mean they'll win, but it is a concern. So with LLCs though, generally, if you want to set up these rules for ownership and what happens if there's disputes, or how to resolve these sorts of disputes, or what sort of decisions have to be made, or how much does it have to be unanimous support to make these decisions, like making improvements to the property. The operating agreement of an LLC is where you tend to lay out these rules of, okay, here's what, maybe we're limiting the number of owners so that it has to be not just our direct descendants or lineal descendant, but it can't be more than X number of people. We don't want, however many people to own this property. Actually, I just had a discussion not that long ago today with another of our attorneys where they had a brilliant idea of setting up sort of like each sort of branch of the family could possibly set up their own board member for this business entity. And, that's the gatekeeper there. So maybe you don't limit the ultimate ownership, but you do have sort of the one person, this is the number of board members and they get to make all the decisions. That's an option as well, potentially. But limiting ownership in some way, or limiting decision-making in some way. So you don't have sort of a vote of 50 different people and it has to be a majority of those 50 people. That's a nightmare waiting to happen. So the LLC provides those rules of those types of decisions, how they have to be made. It can also have rules in there. Ideally, you'd have some sort of like buy-sell agreement with that, which is where you say, okay, if somebody does want to sell their share and they do want out, what are the sort of, how do you appraise that value? Do you have to agree? How many appraisals can you get? Does it have to be the averaging of those appraisals to make sure that it's fair? Or can they kind of circumvent those appraisals if they all agree? And what happens, do they have to give the family the right of first refusal? And if that family decides not to purchase in, then can they look to a third party? There's a lot of, I'm sort of rattling off a bunch of different options here, but these are the types of rules you can set up in that buy-sell agreement for how somebody can get out, or how they are fairly compensated if they do want to sell their interest. And are there any triggering events in that buy-sell agreement? Like if someone passes away and they leave it to their spouse, does that spouse have to then sell? Can the company just force them to sell their interest back, or the LLC, can they force their interest back for fair market value, just to make sure that we don't maybe have kind of non-direct descendants owning that business? So limiting the number of owners is important, or number of people making decisions is important, because you just don't want this sort of decision by, by like mob rule, right? That could be a dangerous situation, and you're in no better of a position than you were before. And again, what I would really recommend is making sure that with these sorts of business entities, that you do have something in there that says, if somebody is not paying their fair share of these expenses, what happens? Do they have to eventually, do they get sort of converted out of that business because they're just not covering their expenses? You don't want to have a non-contributing member. They can't just get to own the property forever and not pay their fair share. That's not fair to the rest of the family members as well. Unless you've all agreed on that, which is certainly something you could do. I don't know that many would. What happens if there is a dispute over any sort of thing that can't be settled amongst the members? Do you have an obligation for them to try to go through like arbitration or mediation? Do you have any sort of dispute resolution tools in there that provide them that mechanism to deal with disputes? And then some people will try to set a direct price on like a sale of an ownership interest, or here's what we say the value of that property is. I generally would recommend against people doing that, because what you set as the purchase price today may not be the fair market value down the road. And are you causing someone financial harm? And one of the triggering events I failed to mention is what happens if there's a liability for one of the owners where they have to get rid of their property, like something like a Medicaid situation for long-term care. Do they, that's a countable asset, but you don't necessarily want a Medicaid lien against your family cabin. So maybe at that point, the rest of the owners do have to buy out that person. It's forced out, or that person is sort of forced out in terms of they're fairly compensated for it, but they can't be an owner. Okay, so I did just get another question. Is it better to leave my name only or put two children on two? Okay, so this is a nursing home related question. So in general, if you're concerned about protecting any property, any real estate from long-term care, whether it's your primary home, family cabins, hunting land, anything like that, the one thing you do not want to do is you do not want to put your kid's name on it as an owner, because there's a couple of things that can go wrong here. One, it's just generally bad tax planning to gift real estate to the next generation during your lifetime, especially not if they're not going to live there permanently as their main address. Main residence, because when you gift property over to them, you transition to them your cost basis in the property. And to think about cost basis as basically, what did I buy this property for? And if they then need to sell that property ever, they calculate the capital gains taxes they have to pay on it based on the difference between the sale price and their cost basis. So if you bought your cabin in 1950 for 50 grand, and today it's worth 350 grand, and you gift it to them, they're going to have to pay capital gains tax on a sale if they do sell the property of $300,000 in gain. So, roughly 20% of that. And, generally speaking, if you pass an asset like that with capital gains associated with a sale, any sort of cost basis with it, if you sell that, or not sell it to them, you transition that to them through your estate plan, through a will or a trust, you actually get a step up to fair market value in that cost basis, at least under current law. So then if they turn around and sell the property, they're relatively close in time, there's very little to no capital gains tax to be paid. Another issue with sort of just putting other people's names on property as a way to protect things from long-term care. So even if you completely transitioned the ownership of that property over to them and you were no longer an owner, one, it's a huge loss of control. So in theory, the new owners could say, well, you're not, mom, you're not allowed to use it anymore, for example. That would be a nightmare scenario, but it has happened to people in the past. Another is you may be protecting it from your long-term care liabilities. Say for Medicaid, there's the 5-year look back. So if you make it out more than 5 years from that transfer, you don't have to tell Medicaid about it. But maybe you made it out 10 years and you protected it from your care. But what happens if one of those your children in that instance, what if they get sued or they get a divorce or they get, they have a creditor issues and they have to file for bankruptcy, anything that can happen to somebody. When that happens to them, it also happens to property they own. So you don't want to open up that property to more liability than you entered that transaction with. And that's where, having that sort of LLC ownership structure is a way to protect against some of that liability. But in terms of protecting things from long-term care, generally a better way to deal with it is using a type of irrevocable trust is generally what I would recommend, because the kids then can be the trustees of that trust, and you're still getting it out of your name if you make it out more than those 5 years. But as trustees of that trust, they are not the owners of that property. They're more like managers. So if they get sued or they get divorced or they pass away or anything like that, that does not then happen to that property. They're not the owners yet. And then you can still get that cost basis adjustment at someone's passing, as long as it's part of their estate when they pass away. So the sort of just gifting the home to the kids or gifting the cabin to the kids, it's a risky move. There's a lot that can go wrong with it, more than can go right. And there's just a better way to do it with that, irrevocable trust-based planning. And if it's a family property like this, sometimes what people will do is they will still set up that LLC and actually have the LLC owned by the irrevocable trust. And then, you kind of have the best of both worlds there. So there's a lot of things you can do with this, but it's not as ideally, you would not just transfer ownership over to protect against long-term care. There would be better ways to deal with it. Okay, so I'm running short on time here, so I have a lot more to talk about, but we may have to do another topic on this later in the summer, maybe. But so next week coming up, if you are interested in this topic, we do have it's another probate related topic that we have. So kind of what personal representatives need to know. And I believe in terms of paying bills, and I believe we actually are going to have one of our paralegals is our settlement paralegal join us for that and kind of explain what she tends to see and the types of issues that can come up, because she deals with it on a daily basis. More directly than we do as the attorneys, because she's the one dealing directly with these sort of accountings and things like that. So that's going to be a really interesting one if you have any sort of questions about how personal representatives need to handle a probate or what types of things can come up and create issues. So please though, feel free to fill out that evaluation form if you would like us to reach out to you to set up an initial consultation. Another good idea here is it's Memorial Day coming up soon, which I completely forgot about until just now. So this could be a great time to talk with your family members if you're going up to your family property, to discuss with them, okay, maybe we do need to set up these sorts of structures, or if you already have an LLC owning the property, how long has it been since you've taken a look at that operating agreement, or do you even have an operating agreement? It's good to look at these every 5 years or so at least, and see if any laws have changed, or if your family dynamics have changed at all, or your desires have changed. Talk with your family members while you're up at your cabin, your hunting land, or the lake, and see if this is something that they're also concerned about. But thank you all for joining me today, and I will hopefully see you guys next week for our probate discussion with our settlement paralegal Valerie. And if you guys have any questions or concerns, please feel free to reach out to us and set up a time to talk. Thanks.